welcome back to our weekly webinar. Happy Dussehra to everyone. Over to Anil sir.
Thank you, Ankit. Welcome to 131st episode of AAA Weekly Webinar Series. Before we go on to the subject, I wish Happy Dussehra to all the participants and all viewers. The subject that was chosen this time, it was only because of the one guidelines issued by the IIIPI, the Institute of Insolvency Professionals of ICAI, and these guidelines are based on various inspections and investigations, or even the orders passed by IBBI, orders passed by IPAs for the conduct of the insolvency professionals. In some cases, they were reprimanded, and in some cases, they were not reprimanded, and their explanation or their submissions were accepted by the IBBI or IPAs. So these guidelines actually will become Bible for the insolvency professionals who are working as IRP, RP, liquidator, or even for assignments of personal guarantors, or even for authorized representatives. This will become Bible because this is a composition. This is a complete composition of all those actions of insolvency professionals which are considered genuine, legal, and compliant, and those actions where the insolvency professionals are asked to improve, either with reprimandation or just a kind of caution or a warning. So this is a very, very detailed composition. First of all, it actually deserves the team of the IIIPI, headed by Dr. Ashok Haldia, and the Rahul Madan, the managing director of IIIPI, and also the chartered accountant Leena Agarwal. They have done a huge work on this particular guidelines. It is a huge book, and the compilation is very large. So in this compilation, they have made it little easy. So the part 1 contains the observations relating to CIRP. Part 2 contains the observations relating to liquidation, and part 3 contains the observation related to insolvency professional regulations. Now, starting with the CIRP, we would quickly go on to the various kind of observations made by the IBBI or IPA, and with regard to various regulations or circulars or sections, or even any kind of guidelines which the IBBI or IPAs think that the insolvency professional have not complied with. Along with this, we are also trying to add some of our experiences, and also we would be saying that this particular observation is based on some IBBI order or some IPA order. So our team actually has worked so that they can relate some of the observations with some of the orders. As we've never done that, any kind of orders passed by IBBI or IPA, we would only be saying the date of the order and also the observations. We are not taking the name of the insolvency professional who was involved in that investigation or in that inspection. The only all the professional colleagues are very dear to me, and I understand, being himself an insolvency professional and also having a team of 75 insolvency professionals within AAA insolvency, we understand that even if an insolvency professional works very hard and try to be diligent and also compliant, the possibilities of error are definitely exists, and that may not be intentional, And most of the time, these errors are non-intentional, unintentional. So therefore, it is important that all insolvency professionals must go through this guidelines, or this particular webinar that we are conducting. This will also be hosted on YouTube by the end of the day today. So maybe within next 2 hours. So it is possible that whosoever miss this uh, active participation in this webinar, they can actually go to the YouTube channel of AAA Insolvency, and then they would be able to see all the observations, because it is important to understand that the uh, listening to something actually is more grasping than even reading yourself. Now, when we see, like, even the observations of the during CIRP has been further divided into subcategories. Like, the first part is the public announcements. So the various observations are that some of the IPs did not provide justifiable reasons with supporting documents for delay in public announcement. They actually have this lacking written records when this particular information was reached to them, when the information reached to them, like it has reached to them through an email or by post, or even for how the information about their appointment as IRP or as liquidator reached to them. Those kind of records are must, just to uh, justify any delay in the public announcement. There are many cases where the even in some of the cases, the NCLT has also observed that when the consent has been given by the RP or by the proposed liquidator, he should also inform, he should also inform the lawyers, or even the he should have the particulars of the lawyers, counsels from the both sides, so that they would be able to inform in case of there is any order passed by the adjudicating authority for their appointment. So the court even expects that after you give your consent, you should observe that case. And while observing, you should also keep a track when the final order is passed for your appointment. So therefore, this is also considered to be a kind of reprimandable flaw, that you are delaying the public announcement and you do not have the reasonable reasons for that, and also the contemporaneous records for proving that the your appointment, information of your appointment actually was delayed, or the service of that order was delayed on you. Then is there is a miscalculation regarding the date of closure of the CIRP. The It is very clear law that even if the order is received by the IRP 1 month late, but the CIRP would be considered as commencing on the date of the order. On the date of the order, the CIRP is considered to be commenced, and accordingly, the last date of the closure, that is 180 days, which is supposed to be mentioned in the public announcement, that has to be calculated accordingly. And if there is any miscalculation about this, that is also not kind of excused by the IPPI or IPS. So therefore, the calculation has to be very, very correct. And also the form CIRP Form 7. CIRP Form 7 is very, very important, because it records the reasons for any kind of delay, not only for public announcement, but many delays. Wherever there is any delay from the timeline, this particular form, CIRP 7, has to be filed every 30 days. Like, suppose I'm not able to publish the expression of interest, I'm not able to release the expression of interest for inviting resolution plans, then CIRP Form 7 has to be filled every 30 days of the delay. So all timelines, if we miss the forms, CIRP 7 has to be filled every 30 days. This is very, very important. And in fact, in case there is a delay in the public announcement, then there will be delay in the constitution of committee, then there will be delay in the period of IRP, the RP appointment would also be delayed. So therefore, the delay is in fact a very kind of it should not have. So in one of the case where the this IBBI has passed an order on 13th September 2023, in this case, the finding of the disciplinary committee of IBBI was that the committee acknowledged the importance of strict timelines in insolvency cases to ensure the time-bound resolution of the distressed asset. However, it is accepted that the insolvency professional's explanation that the delay was due to delay in communication from NCLT, which was beyond his control. Therefore, the DC, the disciplinary committee of IBBI, dropped this allegation, and it was one, the importance of the communication is important. One must keep the record of the communication of the order of the IBBI that has to be protected. So in another case dated 30th of January 2024, IBBI passed an order again on the public announcement. And in this particular case, the decision of the committee was the disciplinary committee found that the reasons provided by the insolvency professionals for the delayed public announcement were not acceptable. The DC concluded that even though the insolvency professional became aware of the order on 29th of September 2021, he still delayed the publication unnecessarily and did not adhere to the timelines required under Regulation 6, Sub-Regulation 1 of the CIRP regulation. Therefore, the DC held that the insolvency professional contravened Regulation 6, Sub-Regulation 1, and failed in his professional duty to promptly issue the public announcement within the prescribed timeline. Therefore, this particular issue, the insolvency professional was reprimanded. As said, I am not taking the name of the insolvency professional. I'm only telling you the date of the order, because what we are interested, like what is right and what is wrong. We are not interested in naming the insolvency professionals who have been where the explanation has been accepted or where it has been rejected by the IBBI or the IPS. Next category is the claim verification. Now, the duty of the insolvency professional, may there be in CIRP or in liquidation, to verify the claim on time. The law provides 7 days time to the insolvency professional for verification of the claim in the case of CIRP, and it should be done within 7 days. In case the claim documents are incomplete, it should actually be recorded, and the communication must go to the claimant within that stipulated time. So that is also any delay in verification of the CIRP, in verification of the claim, actually can delay the entire process. The constitution of the committee can be even delayed. Now, one error which is actually very, very important, that the admission of uninvoked bank guarantees. Like in case the corporate debtor has given any corporate guarantee, so that is one issue. And the other issue is that the bank has issued bank guarantees and also the letter of credits or even the letter of comfort. All this is called non-fund based facilities. And in the case of non-fund based facilities, the claim cannot be accepted unless the bank guarantee is invoked or even the LC is failed, like the letter of credit has actually been invoked and the bank has to pay that money to the beneficiary. So in this case, the admission in some of the insolvency professionals have in fact admitted the claim of outstanding bank guarantees. Those are uninvoked those bank guarantees actually should have been admitted to the CIRP only on rupee 1 as contingent claims. It should be recorded that there is a contingency and the claim should be accepted, but unless it is invoked, it should be accepted only as contingent claims, and it should because it impacts the voting share. There are many cases in the case of infrastructure, in the case of CPC businesses, that the fund-based facilities are just 10-20% of the total facilities. In case the total facilities are, say, 1,000 crore, out of those 1,000 crore, maybe only 200 crore is the fund-based facilities, and rest of the facilities will be non-fund based facilities. So therefore, in case there are 100 bank guarantees are issued to various customers, various government organizations, and the out of those 100 only few are invoked and other are not invoked. That means the beneficiary customer or beneficiary government organization has not invoked the bank guarantee. So therefore, the claim cannot be accepted. The claim only should be accepted in case the bank guarantee is invoked. Otherwise, it is a contingent liability. IBBI has also issued a circular in this regard. The circular number is 36 of 2020, and that is dated 27th of November 2020. So in this circular, the IBBI has clarified that such claims should be admitted only as a contingent claim, and in case any bank guarantee gets invoked during the CIRP period, the claimant will inform to RP or the liquidator, and then the claim would be accordingly modified, and a fresh list of committee of creditors would be submitted to NCLT. So this is something which is very important, and most of us are making mistakes regarding this. Then the IBBI, IPA, and NCLT expects from the insolvency professional that communication must go to the claimant in case the claim is not accepted fully. If it is rejected partially or fully, the communication must go. However, the court has also held that in case the claim is admitted exactly as it is submitted, then the communication is not required to be submitted, but the list of creditor which is uploaded on the website of IBBI must have that name, because the columns in that particular list also says how much claim was submitted and how much is admitted. So the lack of communication can lead to disputes and also affects transparency. That communication is something which is advised by the IBBI and IPAs and also NCLTs. So we all have to be very, very clear that Section 18 subsection B and Section 25 subsection E should be completely adhered to, and also keeping into consideration the regulations 13 sub-regulation 1 and regulation 14 of the CIRP regulations. So therefore, the revised list of creditors not shared with the PRA or SRA. That is also one of the very common mistake, that the creditor list are actually increasing nowadays every day. Because earlier, RPs were having the power to admit a claim within even 90 days from the commencement of the CIRP. But now the RP actually can admit the claims even like first of all up to the date of release of RFRP, and then subsequently the any document which are any claims which are received from the date of issue of RFRP to the last date of the meeting in which the resolution plan is approved a week before. All these claims are also supposed to be presented before the COC along with the RP's comment, and then the COC will also add its own comment, and the RP is also supposed to submit an application to adjudicating authority for the condonation of delay on behalf of the claimant, and also have to provide his own observation whether to accept or reject, and also have to provide the observations of the committee of creditors whether these claims should be admitted or rejected. So therefore, the list of creditors are getting revised almost many times during the CIRP period now. It can be because of any kind of claims, belated claims, any claims finally approved by the RP and the COC, any claims which are changing because of the non-fund based facilities, because of the invocation of the bank guarantees. So there may be possibilities that during CIRP there are 10 times or every month the list of creditor is revised. So therefore it is the observations of the IBBI and the observations of the IPA and also NCLT says that this list of creditors must be shared with the prospective resolution applicants as well as the successful resolution applicant, because in case we don't do that, that also will lead to the disputes and also the distribution, and therefore the implementation of the resolution plan can be adversely impacted. This is also clarified in the IBBI circular number 47 of 2021, and it is dated 24th of November 2021. That is something which is also a very, very common mistake, that the list of creditors are in fact not getting informed to IBBI or submitted to NCLT or informed to SRA and the PRA, or even the information memorandum is not updated. So what we need to do whenever there is a list of creditor is revised, then as information memorandum has to be revised. Information memorandum has to be shared with the committee of creditors. The list of creditors has to be submitted to the NCLT. The list of creditors should go to PRA and SRA along with the modified IM. So this is something which is very, very common mistake by the insolvency professionals. And also the courts have observed that there is one document called Form H, which is to be submitted along with the application for approval of the resolution plan. That is called compliance certificate. RP need to give that Form H saying that all the compliances were done during the CIRP. So this is then the incorrect form submission. The courts have observed that the figures of the claims given in Form H is different. The figures given in the resolution plan is different. The figures given in the modified and the last information memorandum is different. Therefore, the action against RP has been recommended in some cases by the NCLT wherever they find that there is a gap between the claims as per Form H, as per list of creditors, as per information memorandum, and as per the information given to PRA or the SRA. So this is something which is very, very important, that the list of creditors must be communicated through all kinds of documents like IM, like the NCLT application, like submission to PRA, and also submission to creditors. Now, in even the calculations, while accepting a claim, the calculations of the interest, the calculations of any other kind of liquidated damages, penal interest, that calculation needs verification. And there have been instances where the calculations are faulty and the RP has accepted as such. Therefore, the claim and the percentage of the voting has gone up significantly. Only because of the calculations, any claim which was actually 10 crores, it was somehow read as 20 or 30 or even 100. Because of the calculation errors, and the RP could not see that. So that is also something considered to be a negligence, because that impacted the voting share, and that can also be considered as negligent, that can also be considered as intentional in some cases. That can be considered as intentional also in some cases. Therefore, checking the calculations, seeing some of the major differences, that must be avoided. Now, the verification of security in trust. Very important to understand whether it is a first charge on the assets of the company, whether it is second charge or subservient charge. Then we also have to see whether the documents for the verification of security in trust as per Regulation 21 actually is provided or not, like the CIRP registration, like ROC registration, like information utility registration, or any other document proving security interest on the assets of the corporate debtor. I have seen mostly people makes an error that the asset which is mortgaged to the bank is not secured, is not mortgage at asset which is mortgaged to the lender is not owned by the corporate debtor. Now, for example, the company has taken a loan of 100 crore and the total loan is secured by a property which is owned by the director. So in that case, in the name of the corporate debtor, in the list of creditors of the corporate debtor, this would be considered as unsecured financial creditor because no property, no asset of the corporate debtor is, in this case, is a security interest of the lender. The security interest of the lender is actually owned by the director or any other relative of the director. Therefore, this loan will actually be recorded, accepted, admitted as unsecured financial creditor and not as secured financial creditor. In this case also, IIPI passed an order on 15th of May 2023, and it was held by the disciplinary committee that the insolvency professional gave an explanation and noting that the confusion arose due to the manner in which the claim was filed. The disciplinary committee found that the insolvency professional made diligent effort to verify the claim based on the available data and no deliberate delay was established because in this particular case, the insolvency professional was able to keep all the records, was able to make the communication and was able to justify the delay because it was not because of his lethargy, but it was because of the lack of documents provided by the claimant. That is also very, very important. In another case, by IIPI on 17th February 2023, IIPI passed an order where it is very clearly held that the disciplinary committee found no evidence that the RP had deliberately delayed the verification of claim. The RP acted within reasonable timelines, responding promptly and completing verification after receiving the necessary documents. Therefore, no violation was found. So what I'm trying to say that one must keep record of the claim verification, communication with the claimant, rather no communication over phone. Rather, phone communication should be followed by a mail or a mail communication should be followed by the phone. Only phone communication with the claimant should not be done because they ultimately will claim that uh, that nothing was communicated with them. Another order on 3rd of February 2023, where in this particular case the decision of the DC was that the information that the IP had violated Regulation 13, sub-regulation 1 of the and the IIPI circular, concluding that the minutes of the COC meetings showed that the verification responsibility was delegated to a third party, which is prohibited. The DC held him responsible for outsourcing the verification process contrary to IIPI regulations. So that is also not permitted. Outsourcing claim verification is not permitted. Only a clerical help is permitted. One can definitely engage some clerks, or even that clerical work can be outsourced to someone for making the Excel list and other things. But the actual verification of the documents actually should be done by the RP or the RP's in-house team. The any kind of uh, uh, data feeding that can be outsourced to any agency and with the approval of the committee of creditor. So NCLAT, in fact, the NCLAT judgment on 23rd February 2023 That is actually very important judgment, and it actually NCLAT has held very clearly that the Regulation 13, Sub-Regulation 2, and Clause C of the CIRP regulations does not mandate direct communication of claim rejection to creditors. Good practice, good practice suggests that such communication should be made to avoid ambiguity and disputes. So, although the good practices says that even if the claim is rejected, it should be communicated and with the reasons. What the NCLAT says, the tribunal noted in this case that although the uploading the claim status on the website was technically compliant, the lack of direct communication led to the confusion for the creditor, which ultimately derailed the process. Therefore, the IBBI is now insisting that in case you want to reject a claim or you want to modify a claim or partially reject a claim, then the communication must go to the claimant. In other cases, only the list is supposed to be uploaded on the IBBI panel so that they are able to see. In another case by NCL 80 in the case of Umesh Kumar versus Narendra Kumar Sharma, the IRP, and it is on 13th of February, again, something similar, which actually we can say the NCL 80 upheld the RP's rejection of claim, ruling that RP acted with the due diligence by seeking further proof. The appeal was dismissed as the appellant failed to provide sufficient evidences. So, Ankit, we are now at the next uh, uh, kind of phase, which is the observations regarding the constitution of Committee of Creditors. You think that we should take some questions for at least 5 minutes?
Yeah, there are a few questions. I think we should take them. So one question is that in one of the cases, CD and OC reached an agreement and submitted withdrawal application under Section 12A within 3 days from the date of order. It is required to issue a is it required to issue public announcement? In one of my cases, Honorable NCLT commented on non-issuance on the ground that the admittance of withdrawal petition listing the matter is more than 3 days from the commencement date, but allowed the withdrawal petition without any objection.
Yes,
So,
I believe this is a very, let's say, good question. Thank you for asking such questions. This difficulty we have also experienced in many cases when the withdrawal application is submitted uh, by the uh, corporate debtor, by the applicant, but somehow it is not reached to the uh, insolvency professional. It is submitted directly to NCLT. But in case the withdrawal application is submitted to the uh, IRP, then I think the public announcement can be delayed by 1 day or so. The observations have been made by even in some other cases. The I have seen that the NCLT has made observations that why the IRP was in hurry. When IRP got the information that this case is being withdrawn and the proof of payment to the or the proof of all these process is also submitted to IP, then the public announcement should have been should not have been done. In other cases, the IRP was like constituting the committee of creditors even before the timelines which are provided in the law, because the timeline says that the from the within 7 days of the last date for the receipt of claims, but then the RP did it much before uh, because there was an application for withdrawal. So there was also, like, it is both way sword. Like in case you do hurriedly, then also the court observes against you, and in case you do it or wait, then court also observes. So therefore, what I would suggest that the insolvency professional must adhere to the timelines. In case you are adhering to the timelines and you are getting the withdrawal information on fourth day, I don't think you should wait, because see, that already means that it is already delayed. So the timelines must be kind of compliant. That's what I say.
Right. Then we have so the claim form was received within the last. Hari Prasad ji is saying that the claim form was received within the last date of submission of claims, but proof of claim was received after 30 days of the last date of the claim. Can IRP admit the claim?
No, if the IRP has this kind
The
of
timelines, I believe that the timelines and the regulations are clear that yes, if the claim is received and certain anomalies are there in the claim, the RP is supposed to write back within a specific number of days, I think 7 days or something. Then the other person is expected to revert back within 7 days. I think all these are mentioned there. So in case somebody does not give the proof of claim within that stipulated period, there can be a rejection of claim. But if it is received after 30 days of the last date of claim, then also as per the present regulations, it can be admitted.
No, it can be admitted. I think the basic question is whether the proof of claim, what kind of importance that document which is missing, that has to be analyzed by the insolvency professional. In case that document is very important and can significantly change the claim, then it should not be admitted. But in case that document is uh, like it may be a KYC document or it may be something different, but the primary claim is seems to be okay, then the claim can be admitted. Also, after the admittance, the further document can be obtained. Some further document can always be obtained after the claim is even admitted.
So, right, all right. So we can do that. Then Anilji is saying that the acceptance of claim beyond 90 days is in the case of home buyers, or is it also in the case of CRP of any other kind of CD? It is for all.
It is for all. It is for all. The claims are supposed to be accepted or rejected by the IRP or the RP up to the date of release of RFRP, and thereafter the claims has to be first of all received by the RP, and RP will present those claims to committee of creditors along with the RP's comment to admit or not to admit these claims, and then the COC's comment will be sought, and after COC's comment, the RP will file an application to adjudicating authority for condonation of delay on behalf of the claimants.
Then Hari Prasad ji is saying that when there is a change in the list of creditors, is it necessary to modify the IM or sharing of an addendum shall service the purpose? IM is a constantly revised document. If we start adding addendums to the IM, it will become very complex, in my opinion. So IM version 1, IM version 2, 3, dated whatever, I think it will keep evolving. Addendums in IM might not make sense in the long run.
No, the see this basically the list of creditors is one of the very important part of the IM, and it can go as addendum or it can go as next version of the IM. What is important that one, it is part of the IM. Two, it must go to the committee of creditors. Also, it must go to the PRA. And in case the resolution plan is even if even to SRA also, in case in some cases the claims are even being admitted at that particular level. When I'm saying that between the voting is being done and the the SRA must know or PRA must know that what is the status of the claim as on the date of voting on the resolution plan. So even if it goes as a addendum or as a next version of IM, it is only a matter of uh, convenience, nothing else.
Then we have Anju ji asking that if RP looks like colluding with one of the unsecured creditors, that is COC members, to bring down the liquidation value to hand over the CD to sister concern of the unsecured creditors, which is the PRA in the CIRP. Unsecured creditors hold major voting share of 80%. In such cases, what is the remedy available to the secured creditor or the other COC members? So remedies are a disciplinary action initiation that you say that, but for that you will have to give a basis to it. So we have seen that many creditors initiate an independent valuation at their own cost, and then they use that valuation report for any such litigation. Also, we see that the RP is normally required to cooperate and share information, facilitate the valuation which is required by the creditors for their internal purposes. So this, I think, is the solution for this problem. Any
Yes.
other suggestions that you have?
No, I think in case you can just crystallize this question again, uh, that
So
will help.
the RP is asking RP, the secured lenders feel that the RP is colluding with the unsecured creditor who is having 80% share in the
But
CO.
I say, Ankit, in this case, that even the any other claimant has a locus to file an application before adjudicating authority in case they are finding any kind of non-compliance.
Hmm.
In case the RP is not sharing the document, that also they can file an application. The first action is that the RP should uh, allow them the inspection of the claims filed by the other parties.
The claims are not the problem here. The valuation is the problem.
No, it's
The
like,
valuation is being undervalued. The asset are being undervalued to facilitate some creditor. That's the idea that one of the unsecured creditors is being. So valuation is the issue.
no, I think then again, what you said, Ankit, that but then like getting the assets valued and asking the RP that uh, we need all the access to the assets for another valuation, and that too independently by a creditor. I don't think that is a process which can be accepted without the approval of committee of creditors. And the committee of creditors can say that yes, one, two valuations are being done by the RP or the liquidator, and now there will be another valuation, and the RP will provide all this information to the third valuer.
The
Now, if
valuation
the valuer,
valuation is not part of the process. No? Valuation is a separate process which is being undertaken by a creditor. So the RP is only providing information.
so I'm still not convinced that the valuation of the property during CIRP can be done by any outsider.
So we have
Because the
done that in a
valuation,
couple of so practically we have done that in many assignments now. So normally the objective of such a valuation when some banks or other people get the valuation done from us, while the companies under CRP is to take an action or take a decision with respect to sale to ARC, a decision with respect to OTS. So therefore for that the banks don't rely on the valuation done during the CRP process. They want a separate valuation. For
no,
that then ask the RP to.
my only concern is if that is permitted. Now, presently, what is happening is that the valuation of the corporate debtor, the liquidation value of the corporate debtor is still a confidential information. And for this particular information, all the creditors are supposed to give an undertaking also that they will not share with anyone. But in case any other agency or any other one creditor is getting the valuation done, and then how does that valuation report will not go to market? So getting a valuation report done and getting the liquidation value of a company, and that too by another person who is not regulated, I think that is a not a non-compliance. They can get it done, but the RP cannot permit this. If somebody can do a desk valuation based on the information available, that of course anyone can use it for their own information. But two valuers are appointed by the RP, and that particular liquidation value is still in a confidential information. The valuation reports are confidential information, but still the valuation can be done by another creditor, and the creditor will have access to all this. I think again, one, the COC approval, and two, the confidentiality undertaking that would be required in case it is to be permitted.
Right. So then we have a question from Anilji that should IRP or RP investigate or probe the genuineness of the documents submitted by the unsecured creditors while verifying the claims? So he wants.
I think to some extent, yes, but not to a greater extent. Because see, it is very clear that the IRP or the RP cannot adjudicate. Even if the claim is disputed, the IRP or the RP has to accept it or reject it, only based on the documents available. So in case the IRP feels that these documents are seemingly forged or not genuine, then of course the IRP can use the normal business prudent, but not kind of appointing an investigating agency on it. A general normal prudence can be used, but IRP is not supposed to appoint a kind of investigating agency for verification of the documents submitted by the claimants. Because see, the submission of a claim, even if it is disputed, it has to be accepted or rejected by the RP based on the proof of claims.
Then what if there is a considerable deviation between the first set of valuers and the second set of valuers? So that's it is not a question to the IRP or RP. Uh, uh, it is basically just part of the process. So if there is a significant deviation, then the third valuer is required to be appointed. That's already part of the process.
Now, see, as far as the duties of the IRP is concerned regarding valuation, the duties are restricted to one, the RP is supposed to provide all information to the valuer, providing them the access. Also, giving them the information about all kind of complications or impediments into the valuation value of a particular asset. Beyond this, IRP is not supposed to be an expert in the valuation. If there is a difference, the RP need to compare. Is there any physical differences, like some of the assets are left and some of the assets are taken by the other person? But if there is a genuine difference about the value only, irrespective of the physical differences or quantitative differences. So the quantitative differences, RP should be responsible, that RP should have seen both the valuation reports. But in case the quantitatively it is all matching and it is only the value perception of the valuers is changing, then the IRP, then the insolvency professional cannot do anything other than appointing a third one.
So we have presented various reports before various COCs, so I can share my experience with you there. So one, the COC doesn't like the idea that okay, the valuation report has come and the valuation report, they seem or they understand sometimes that the valuation report is not even read by the RP. How do they know that some factual errors are recorded in the valuation report, which the RP also knows and the COC also of course is aware of about the company. Then there are certain documents that the valuer is saying is missing. So although bank statements are available, bank statement might have been provided, not provided by the RP, but the valuer says that the no bank statements is not available, therefore I'm not even valuing the bank balance in the company as on the CIRP date. So that's a red flag that okay, you have not even gone through the report. The RP has not even gone through the valuation report. Then next, in case there is any difficulty with respect to documents, that's also something I've talked about. Then physical inspection is something that they can raise a red flag on in case something there is something is recorded which is not as per actual. So factual information, some assumptions which are glaringly wrong and unacceptable. These are possibilities that can be troublesome for the RP. So
Yes,
reading
Ankit, I
through
think
the yeah, that's
we can go ahead with the next phase of these guidelines. So these
yes.
are the guidelines on the constitution of committee. So there should not be any delay in the constitution of committee, as we have seen in many cases where the Section 12A proposal actually comes, and then there are a lot of pressures on the IRP not to constitute the committee. But the IBBI and the IPS says that the uh, IP should not come under any pressure. IP must meet the timelines. In case there is a time for constitution of committee, it must be constituted, even if a 12A application is pending before the adjudicating authority. Then, like again, it is considered like a non-constitution of COC due to settlement or withdrawals. That is something it is not pardonable. That the IP did not constitute the committee because of the settlement or because of the withdrawal proposals. Then the in operational creditors were not included in the COC. that is also reprimandable, and the operational creditors should be included as invitee or as members in case there are no financial creditors. That also must be seen, and the list must be seen from the books of account or other resources, that the communication must go to all the operational creditors so that they file their claim. Even the delay in filing their report to the adjudicating authority regarding constitution or reconstitution of committee of creditors, that report must go to the adjudicating authority. Voting share allocated to the related financial creditors, that also, because see, there are some orders which actually says that the uh, despite the information with the IRP, the related party status was not updated, and the COC meeting was COC meetings happened without even giving them a tag of related parties, and certain decisions were taken. This is also considered to be a non-compliant. Reconstitution is not done promptly, the new claims not accepted promptly, the new modifications not done the promptly, the new assignments not recorded on time. So the reconstitution of the COC must be done promptly so that no further actions can be approved by the existing committee of creditors, and it should be only got done by the actual committee of creditors, reconstituted committee of creditors. So in this case, we have the IBBI order dated 20th of July 2023, where it has been held by the DC that the RP's explanation, RP explained in this case, and it was delayed, that the delay was caused by the complexity of verification of the claim, and it was not due to failure in the RP's duties. No action was taken on the RP. Now, like even the next subject is the some of the errors or mistakes which are common in the case of authorized representatives in class of creditors. So the financial creditors as a class of creditor, they also like so there are errors which has been observed, that the AR attended the first COC meeting where the uh, official announcement by adjudicating authority is not yet done. So there are some orders where this has been kind of considered as reprimandable. However, the regulation 16 of CIRP regulations was amended on 24th of September 2024, very recently. In that particular regulation, the IBBI actually considered that in most of the cases it is not possible that the AR actually is appointed, because see, when the committee is constituted, the immediately separate application is required for the appointment of AR. So that may take time in getting an order from the adjudicating authority, and the meeting has to take place within 30 days uh, from the public announcement. Then in that case, in that case, what happens? The uh, in case the authorized representative is not called to the meeting, then how the voting would be done in the case of class of creditors, how the resolutions would be passed, everything would be delayed. Even the RP would not be appointed because the class of creditor may be larger than other things. So therefore, the AR's presence in the meeting and also the AR's handling of the proposed voting process actually is necessary. So when the IBBI considered this, and IBBI considered that this is a genuine difficulty faced by the insolvency professionals, therefore they amended the regulations that even if the recommended name is not appointed by the adjudicating authority because of the time delay, the authorized representative who has got the maximum voting is permitted to attend the meetings of the committee of creditors and do all acts as if he has been appointed by the adjudicating authority. Even in some cases, the appointment of AR, the process is not considered as kind of transparent or or ambiguous. So therefore, the process of appointment of AR should be a kind of transparent, and the that's something which is also in one of the case dated 16th of July 2024. The IIIPI's disciplinary committee, in fact, has given a decision that the DC of the IIIPI says that the RP's explanation, noting that the voting by the home buyers was properly conducted through the AR, and that the participation of the legal representative and home buyers was approved by the committee of creditors. Therefore, the DC found no violation and accepted the RP's submission. Now, relating to conducting the COC meetings, sending notices, preparing minutes, and the timelines for the votings and the approvals. Now, uh, the delay in conducting the first COC meeting is not pardonable. Shorter notice sent for COC meetings without even their approval, without their prior approval, is also a non-compliance. Non-sharing of notice with suspended board of directors is also a non-compliance. Written records not maintained for attendance, for voting, for even decisions, the written records are not maintained. Even the agenda must be bifurcated. Agenda should be bifurcated between discussion and voting. So the agenda is something like it should have two parts. One, that what would be discussed, and second, what would be the voting agenda. Then the team members of the in some of the meetings, it has been seen that the team member of the insolvency professionals chaired the COC meeting. Team member chaired the COC meeting, it is not pardonable. The team can be along with the insolvency professional. The team cannot be without the insolvency professional. The insolvency professional, who is RP or the liquidator, must be present in the meeting, virtually or physically, and he only would be the chairman, and the other only can assist him doing all this. In the case of, in this particular case, the High Court of Karnataka, in fact, has given an order on 21st of November 23. And in this case, the decision of the Karnataka High Court was, this decision of the Karnataka High Court was that the shorter notice of the COC meeting violated procedural requirement. The resolution plan approved on 11th of February 2020 was invalid. The COC must consider the petitioner's restructuring proposal under Section 12A of the IBC. The petitioner could file a complaint against the RP with IPBI. So this is what is the order of the High Court of Karnataka in the case of Farooq Ali Khan versus Punjab National Bank, and this is dated 21st of November 2023. So this also highlights the importance of giving timely notice, proper agenda, bifurcation of the agenda items, proper records of voting, and the proper transparent and judicious conduction of the meetings. So in the case of even very old judgment at 31st of January 2019 judgment from Honorable Supreme Court in the case of �𝐤𝐚𝐢𝐥 versus Standard Chartered Bank. In that case also something slightly relevant was important. In this case, what was held? In this 2019, in �𝐤𝐚𝐢𝐥 case, it was held very clearly by Honorable Supreme Court that the members of the suspended board of directors must receive notices and copies of resolution plans before COC meetings. It ruled that the RP must provide these documents to ensure the suspended board can participate effectively, as their interest could be affected by the decisions made. The Supreme Court emphasized that while they have no voting rights, their participation is crucial for providing input on the financial position and safeguarding their interest as stakeholders. This Supreme Court judgment actually is making all this participation by suspended management very important, and they are also crucial in the decision-making process as the decisions may impact them. Even in the case of IBBI order dated 14th of April 2021, the IBBI, in fact, disciplinary committee accepted the IP's explanation that noting that no harm or prejudice was caused by the shorter notice since all members participated. While acknowledging the procedural breach, the disciplinary committee took a lenient view and did not impose any severe penalties, emphasizing the importance or adherence to timelines in the future. So, lenient view is different, but this is again said that it is important to comply this. In the case of, yes, Ankit, in case we can take up some more questions because the time is already up, but we have not been able to even cover the 50% of the guidelines. How do we take it up? Should we have part two for this or not? What do you
I
suggest?
think these are all very practical questions. We can have a part two to it. And I think what we can do is we can also answer some questions that maybe, they can come offline and others we can take up next time. So maybe that is a good idea.
So I think this work of IIIPI is commendable, and all the insolvency professionals must go through this as we are trying to crystallize all the findings, present it before you. We would be doing a part two of this also. In the part two, we would be covering the rest of the CIRP and also the liquidation processes and also the non-compliances of some of the IP regulations. So therefore, please be connected in the part two also. We would be deliberating on all this, which is important for most of the insolvency professionals. Yes, Ankit.
Right? So I think we will take a part two and then take it forward.
Thank you. Thank you.
Thank you, everyone. Thank you.
It is our way of learning. Thank you.